Today's voiceover talent is more than just a pretty voice.
Pretty voice.
Today's voiceover talent has to be a boss.
A boss.
Join us each week for business owner strategies and success with your hosts Ann Ganguzza and Gabrielle Nistico, along with some of the strongest voices in our industry.
Rock your business.
Rock your business.
Rock your business.
Like a boss.
Like a boss.
Rock your business like a boss.
Rock your business like a boss. A VO boss.
A VO boss.
A VO boss.
Hey, welcome everybody to the VO Boss podcast. I'm your host, Ann Ganguzza, along with my VO Boss bestie, Gabby Nistico. Gabby, today we have our very first repeat guest.
Only took us 3 years.
Voice actor, baseball coach, and lawyer, Rob Siglampaglia.
Thank you for having me. I'm honored. I didn't know I was the first repeat guest. That's awesome.
Well, Rob, we got a lot of stuff to talk about today.
Yeah, there's been a couple of different instances these last few weeks, and Ann and I have really been wanting to do an episode about it, and I kept saying, here's the thing. I'd love to talk about it, but we really need to bring in an expert, and I'm pretty sure we both know who it is. And we've been holding off on recording this until you were available.
For sure. So back in, I think it was July of 2018, I approached you because I had been alerted to something on a Facebook group that somebody was using a domain that was very, very close to VO Peeps to set up a site to solicit for business, for voiceover business. And they were looking for talent to sign up, and ultimately it was called voicepeep.com. And so I brought that to your attention and I said, Rob, what can I do about this? I don't want this to affect my brand. And you had written back to me and said, well, we can certainly look into trademarking it. So I had decided at the time to ask you to go ahead and trademark both VO Peeps and VO Boss. Tell us a little bit about trademarking, Rob, and why it's something that we might need to think about in our businesses.
Sure. There's common law trademark, and there's official registered trademarks. Common law trademark is basically when you set up a business and you start using a name, and the name kind of becomes known, and it becomes known as associated with your business. That's a common law trademark. Very difficult to protect the common law trademark. So you would want to go through the registration process. You can register a trademark with many states, have their own registration processes. So like if you have a local business, it probably would be smart to register it with your state. And then there's the federal process. There's the United States Patent and Trademark Office, where you can register your mark. And for us voiceover artists, that's the smart move, is to register with the federal office, because then it basically what it does is it puts everyone on notice that as of the date you registered, you're taking claim to that mark for your business. If it's a product that you're selling, that's a trademark. If it's a service like what we do, that's a service mark. I mean, that's just semantics because they're basically the same thing. It just depends on the business. Basically what you're doing is registering, and you're letting everyone know when you started your business also, because like you don't have to trademark it right away. You could file the trademark even before you start your business, but then you have to, once you do start, you have to show evidence that you're actually using the name in business. So what it does is just puts everyone on notice that that's your trademark, you're using it in business as of such and such a date. Then you can protect it.
Well, I remember being upset because what I didn't want was to have this domain tarnish my brand. So we went ahead and did the federal trademark. I remember you sending me an email on Christmas, actually. I think we put it in motion in July, and on Christmas, I had gotten the notice of publication confirmation for VO Peeps. And you were forwarding me stuff on Christmas Day, so there's dedication, guys.
Well, yeah, I just forwarded it from the trademark office, so they, it's done by computer, obviously. So
so that was just a notice of publication. So what does that mean?
Yeah, so basically what happens is when you're registering a trademark, there's certain things that requirements you have to meet. So first of all, you have to let everyone know what business category you're trying to register the name. You can't just register a name and no one else in any other business, to exclude them. Mm-hmm. So it's basically you're letting everyone know that I'm a voiceover artist. I'm going to use this for voiceover. That's my business. And you file the application. You show evidence that you're actually using that mark in business. And then what happens is there's an attorney that's assigned by the trademark office, and they review everything. And sometimes they come back and say they want you to revise and review this, and this. They'll give you a whole list of things with a bunch of legal mumbo jumbo as to why you need to fix this and that. Sometimes I debate with the trademark attorneys, and you kind of work things out. Because then what happens next is that trademark, the application, gets published in the Federal Register so that someone can object to it.
Got it.
If they file an objection saying that it's too close to their mark, then you have to deal with that objection.
Now, is that also so other people can search to make sure if they choose a business name that it's not the same? Is that also a purpose for? Well,
you can search for the applications that have been filed and that have been granted. So before I'd even file an application, I would search, and I would do a deep level search. I would search common law, state law, and, Google. I do a Google search, and I'd do a federal trademark search to see if there's anything that I think is going to raise an objection.
So how close is too close? What helps to kind of define that line?
Okay, well, let me give you a couple of examples of objections that I've gotten. My daughters, actually, they're twins. So they started a newsletter called Twins Times. That was a blog. So I said, yeah, that's a great name to trademark. So I filed the application. We get all the way to the publication process. Major League Baseball, Minnesota Twins.
That's what I was thinking.
And they objected, and they said, we don't want you to use this in Major League Baseball at all. They were talking about softball stuff, so we worked out a deal where we just put a disclaimer up on the blog that we're not associated with Minnesota Twins or Major League Baseball. And they also made us agree that if they wanted to do like their own newsletter called Twins Times, that we would be okay with that, and they would do their own disclaimer. So that's how we worked it out. So that's, but wow. I could have said no, we're not going to agree to this, and then it could have gone through the federal litigation process. It goes to federal court at that point, and then you can litigate it.
Wow. So I trademarked VO Peeps, the name only, correct? You can also trademark logos as well.
Correct. Yep.
So what would be the advantage, or is there an advantage or disadvantage to also trademarking my logo?
If you trademark the name, then just the name is trademarked. But if you have a special logo, like Coca-Cola, so they'll trademark those as well, so people can't steal that artwork.
Got it. Got it. So it's just so they're completely separate then.
Yeah, right. You'd want to do two separate applications normally, unless the logo, like some logos have the name, but it's just like one of the letters is intercrossed or something like that, but you can still make out the name. So then I would just do the logo, because then both are protected. But that's you have that's a call that an attorney would really have to make. You want them to have as broad coverage as possible. That's the point of doing the trademark application and figuring out what category of business it goes in. You want to try to make it as broad as possible. And you want to protect your VO Peeps, so you want to make it as broad as possible. So if you just did the logo, that's narrowing it.
Right.
So you want to make sure that you're not, that you're keeping it as broad as you can, so that you exclude as many people as you can that are trying to, get around your trademark.
And I had my group for such a long time. I probably could have tried to fight that using the common law, but I was lucky because I don't believe that business ever took off. And because I had not filed for a trademark, until I saw that, and then it was almost too late. And I think you had mentioned to me that we could have tried to fight that, because I had been in business for so long. But it helps certainly to have a trademark for that.
It helps.
So I was lucky, and I didn't, and it is a kind of a process, because I didn't actually get the trademark certificate for both VO Peeps and VO Boss, which I'm so thankful for, because I had another incident with VO Boss until March of this year. So that was a good, I would say, 6 to 8 months of a process of filing, having it out there for publication, which I assume they must let it sit there for so long.
30 days.
30 days? Okay.
It's published.
And then to award the trademark certificate.
Yeah, I mean, it's the government, so it takes them, they have to assign an attorney. The attorney has to, go through everything. Then they have to see if it's, they're going to want changes, which many times they want some changes. You have to send a specimen That's what they call it, a specimen, as to show that you're proving you're in business. So like if you're selling shoes or something, you need to send like a web page with the cart showing that you could buy the shoes for whatever amount of money. Or if you don't have that, you have to send pictures. And a lot of times they want more specific specimens. That's like the most common thing that you'll get from the trademark attorneys. The other thing is that they think it's too close. They also search to see if it's going to conflict with another name. Mm-hmm. So sometimes they'll do that. Other times there may be an application that's filed that they think is close, so that they'll suspend both applications, or they'll suspend the later one until the earlier one is adjudicated.
Well, I'll tell you, I am so thankful that I did it, because we then had just recently an issue with the VO Boss trademark, where it came to my attention from someone who pointed out there was a website out there called VoiceOver Boss, and it was a new website where the person was trying to sell courseware for people getting into voiceovers, and the whole story was, I started off on Fiverr, and now I only work 1 day a week, and so you too can be a successful voiceover artist. And this person had social media set up. They had Facebook page. They had a website. Not only was it voiceoverboss.com, but it also had a tagline from one of our very good friends' books that has been out for a while, Elaine Clark. There's money where your mouth is was the tagline, and it had the font and the colors of one of our sponsors, voiceovers.com. So there was all sorts of things going on there. Gosh, it just made me angry. And when I contacted you, Rob, I was like, what can we do? And he's like, well, we can certainly send a cease and desist, because now we have a trademark. But let's talk a little bit about that, and what are the actions once you have a trademark and you feel somebody's infringed on it? What's the process?
Sure. And that's actually one of the major benefits of filing and registering and going through that process, because you have statutory remedies under the law. So even if you're not actually damaged, because you'd have to prove some kind of damage otherwise, you can rely on the statute, which has penalties in it. So if the person keeps infringing, you can just take them to federal court and ask for statutory damages, and the court's going to set an award based on the statute. Basically, you don't need to send a cease and desist. That's, most people do because they don't want to go to court.
Sure.
You could just file an infringement action if you want to, but and it does happen very often with the big companies, Apple versus Samsung, whatever. They just file a suit. They don't send a cease and desist because they got to get in there right away. Yeah. Because for them, it's millions and millions and millions.
Sure, there's opportunity.
Potential damages.
Yeah.
You can send a cease and desist, which basically just says, stop using my trademark or I'm going to sue you. So, it's a demand letter because they've already infringed, even, when you're sending the cease and desist, because they have a duty to check themselves, the Federal Register, or the Federal Trademark Office, to see if someone's using that name. And it's very simple to do a search these days. So.
Right.
You don't have to send that cease and desist, but you did it to make them stop because nothing had happened yet, basically. So that was a good course of action.
But it was all set up to happen. He had domain name, website, email. He had everything under that domain. So I assume that he had a considerable amount of effort and investment. Maybe not considerable, but he definitely had invested in it thus far and was getting ready to launch.
Exactly. He was just starting to launch it. So it wasn't something where it was going to, it was, if it had been in existence for 5 years, say, it would have been a different.
Might have been a fight.
Yeah.
Might have been a different battle.
Different back and forth for sure. So
interesting. So I actually did catch it, I guess, in the very beginning, and asked you to send your advice, and you had said, "Well, let's send a cease and desist." And I said, "Do it," because I was livid at that time, and thankfully it worked out. And I believe when you send the cease and desist letter, it's 10 days. They have 10 days.
Well, you could say whatever time you want, but I put 10 days because, like I said, it has the potential to start causing you damages if you don't try to catch it quick enough.
You know, this makes me think, isn't it just coincidental that he took a name that was similar to something in the voiceover industry? He took a font and a color, right, of all these other industries all these other businesses that were successful and was trying to then launch his own business. I feel like that was just an intentional thing.
It could be. It could have been intentional. He was probably trying to emulate those things.
Mm-hmm.
You know, I don't know if he was intentionally infringing trademarks, but, you know, he was borrowing. Put it that way.
Yeah, exactly. So I'm just wondering if that's a strategy or a tactic or you're finding things like that. You know, is that a common occurrence? Is that something that you've seen before?
Yeah, absolutely. That happens.
Mm-hmm.
I mean, it happens all the time. I mean, you know, people that are successful in business, other people want to do the same thing. So they, you know, follow that business model. And a lot of times they copy the intellectual property as well. So
what do they say? It's the sincerest form of flattery.
Exactly. Right.
See, Gabby, how successful VO Boss is.
Rob, what does it cost to file the trademarks, to maintain them? What's a rough idea so people know?
If you're going to do it completely online and you're going to use a whole bunch of categories that are already preset by the trademark office, it's $225 per class to file an application. So per class would be like voiceover would be like one class. If you're going to do like acting, voiceover, education, you're going to sell some mugs or products, like that would be 4 classes. So it's expedited application online. It'd be $225 per class plus the attorney's fees. I charge around $500 for attorney's fees to do it, which includes the search and everything. So I do that search before.
And how long is the trademark actually good for?
Trademark is good for 10 years. After 5 years, you have to send evidence that you're still using the mark, so that costs like $150 or $125, something like that. And after 10, you have to refile. You go through the process again. And
tell me if I'm wrong, but I feel like social media is where we see the most infringement right now. You know, I've had VoiceOver Vixen trademarked for a really long time, and I will occasionally see, you know, people use it on social media or, you know, as a hashtag. It's one of those things where you kind of go, ignorance is not an excuse, right?
Yeah, social media and the internet that's really how infringement's happening these days. I mean, because it's just the easiest way for people to communicate.
Gabby was telling me even the other day, right, about what happened with our good friend and colleague Lisa Biggs.
Lisa Biggs. Yeah. I think someone else found it and brought it to her attention that a woman in the Philippines was using Lisa's photo, multiple photos of her, different photographs, and promoting herself as a voice actor on Fiverr under a different name. It was crazy. And when you pulled up her Fiverr profile, there was 3 or 4 photos of Lisa.
Wow.
Is that
so?
That's
She
identity
immediately,
theft,
of course, reached out.
Yeah.
Told her to knock it off.
What is that classified under? Is that copyright, Rob?
That's identity theft.
Identity.
That's a crime.
Well, okay. So
yeah, that's even further than trademark.
Further than that.
Trademark is it's basically just your name. You know, your trade name with trademark infringement. Occasionally I see bootlegged copies of my book up on the internet too, and we have to write to get it pulled down, and it just happens. I mean, it's the internet. That's why it's important to protect these things.
Right.
And I mean, we've seen this elsewhere in voiceover too. We've seen people's logos be lifted and minutely changed and, you know, repurposed, and there's so much of this going on. But in a case like what happened to Lisa, with it being international, what are the laws? Do we have anything that protects us? How does that work?
Well, that's clearly a crime. But I mean, when you're talking about places like the Philippines and China and those types of places, good luck. You know, you'd have to go like get the FBI involved and stuff, but they're not going to deal with that. I mean,
right.
They're trying to find missing people and stuff. They're not going to deal with that kind of stuff. So, I mean, basically what you'd have to do is contact Fiverr and get them involved and get them to pull the pictures down.
Rob, if we can, let's talk a little bit about copyright, because I, reading the forums the other day, and I saw you were involved in a discussion about copyright.
Trademark, copyright, this is called intellectual property. I see all over voiceover artists, like you just said, Gabby, you see like they'll take logos and change them. I even see that voiceover artists take famous logos and change them. They borrow them, as I say. It extends to demos too. People will take a Stephen King book and read 5 pages of the book and put it up on Facebook. You're probably not going to see like the FBI at your door, or Stephen King's not going to show up. But that is copyright infringement. Technically, if the publisher wanted to, or Stephen King wanted to go after you for whatever reason, they could do it, or sue you. Are they going to do it? Probably not. But there are certain companies out there that will do it. Like Disney, they're gonna chase you. The Minnesota Twins. Look, Major League Baseball. So it's not whether they're going to do it, and that's what everyone argues. No, they're not going to chase you. Don't worry. That's not the point.
Right.
Whether they decide to exercise their rights or not, that is a separate question. Then can they? And they absolutely can. You have a car. You own the car. You can say who drives the car, when they drive the car. Same thing. Intellectual property, you own the words, the ideas in that story. So you are the one that decides who can reproduce it, who can publish it, who can put it out in public. So putting music on demos that, that's you don't have clearance on, the writers can come after you, the publishers. Taking pictures. And I actually have a couple of cases going on right now where voiceover artists will download pictures off the internet, and they've gotten bills for those because they didn't license them properly. That's a big thing now because there's actually a couple of companies out there that have been created just to like scour the internet for these automatically.
And I've heard of them too. I've heard of some people just getting fined and.
Yeah, saying no, that's my photo.
That's my property.
I want $200 or whatever, or $700, whatever the number they make up. And basically, all you really need to do is ask for permission. If you wrote to the publisher of Stephen King's book and say, "Can I use these 3 pages? And I'm going to post it online," they're probably going to say yes. 99% of the time, they'll be like, "Sure, no problem." You can't just assume that's okay. It's not. You'll see it all the time on the groups, and I hear it a lot where people come to me. A client who they gave permission to use their voiceover for a year, say, after 2 years, they're still using it, and they want to go sue them or chase them or get money from them for, using their voice for more than a year. It's the same laws that they're going under for that to collect, and they go crazy about it. So it's like when it happens to them, it's like the end of the world, but they have no problem going to take the book and read it. And, artists need to respect other artists' work.
That's a great point, Rob. Thank you so much for saying that.
Yeah.
And Rob, please share with us the name of your book and, of course, your website and how folks could get in touch with you if they want to retain your services.
Sure. Yeah, the book is Voiceover Legal, voiceoverlegal.com. Really hard is the site. And I've been working on the second edition for so long, and it's going to be out soon, but I just need to stop coaching softball and it'll be out one of these days. But the book is still obviously valid, and they can contact me. Probably the easiest way is through my website, my law website. It's robscigesq.com.
Thank you so much for helping me with my trademarks and VO Boss. He's amazing. And Rob, thanks so much for being with us today for the second time. Yay!
Yay!
Yeah, that's so cool. Thanks.
I'd like to give a big shout out to our sponsor, IPDTL.
And of course, voiceovers.com, who, if you haven't seen it, they just released a big video about what's going on. There's all kinds of activity happening. They're getting ready to do a soft launch on the new platform, voiceovers.com.
Okay, guys, have a great week, and we'll see you next week.
Bye.
Bye.
Join us next week for another edition of VO Boss with your hosts, Ann Ganguzza and Gabby Nistico. All rights reserved. Ann Ganguzza voice talent in association with 3 Moon Media. Redistribution with permission. Coast-to-coast connectivity via IPDTL.